All right, everyone. Welcome to One Civil Law. Hope you're having a great day. So, we are going to be tuning in for the plea deal of Bryan Kohberger, who is set to plead guilty to 4 counts of murder, plus, I believe, a count of burglary in Idaho. The recommended sentence, I believe, is life without parole times 4 to be served consecutively, plus whatever the penalty for burglary is in this state, which is probably like 10 years. So probably lifetimes 4 consecutive plus 10 years. Um, it doesn't appear that the sentence will be given today. To be given to the victim's family will have time to give victim impact statements. And it also appears the plea deal does not require Mr. Kohberger to give a full accounting of his crimes. It requires him to do just the bare minimum, which is just basically admit to the elements of the crime and nothing more. And I am salty about this, and I hope the judge will insist that Mr. Kohberger gives a full accounting, because the judge can do that. The judge can reject a plea offer of guilty. And so I'm hoping the judge will do that, but probably not. Probably not, which is very irritating to me. But I'm secretly hoping the judge will have judge balls and be like, "No, I'm not accepting your guilty plea. You can't plead guilty until you do what I want you to do, and I'm going to make you my bitch. And until you say yeah, until you do the things I want you to do, I'm not going to take your plea." So that's kind of what I'm hoping he's going to do, but we'll see. Probably not. But he can. He can. And I hope he will. I hope he can. We'll see. Yeah, Lord. Yeah. So we are just waiting for the court to start here at the top of the hour. I don't necessarily blame the prosecutor. Well, I kind of blame them for not insisting on the full. I'm calling it an allocution. Travis was trying to correct me that it's not an allocution. I think it is an allocution. I mean, it's not normally what we use the term allocution for. Travis is correct that normally allocution is the portion at the end where the judge says, "Do you want to say?" Normally, allocution is the portion that's sentencing, basically where the judge says, "Do you want to say anything on your behalf?" That's the normal way we use the term allocution. But I think this also is an allocution. I otherwise don't know what to call it. In the same way that voir dire can mean multiple things, like voir dire can mean we're checking out a witness in terms of their professional credentials, but voir dire is also used for selecting a jury, for example. So I think it's still called an allocution. But if there's another term for it, someone will let me know. I don't know what else you would call it other than an allocation. So I'm calling it an allocation for now. And maybe someone will correct me on my verbiage. So we'll see. Can they release motive information after sentencing? No, not really. I mean, they don't release anything. They won't release any of the evidence. So nothing will be released. Everything will remain closed. So yeah, so they won't. I mean, they probably. I mean, I suppose they could. I suppose they could speak to those issues, but they probably won't. So yeah, I would imagine that the file will be closed, and we will never learn the details. I would like to know, among other things, I'd like to know, when did he first get the idea for this? What inspired him to do this? What was his thought process in deciding to do it? How did that work? When did he finally decide to do it? Then how did he go about, actually executing upon his intent? What did he do? Did he select a particular victim or particular victims? If so, why did he pick those victim or victims? Was there any particular reason he picked those victim or victims? Did he do anything in terms of prep, in terms of surveilling, stalking, or otherwise casing the scene or casing the crime scene in advance? Did he do anything like that? What did he wear anything such as protective clothing to prevent, DNA from being transferred onto him? How did he go about, what did he actually do? I want him to actually say that, I went into so and so's room and I stabbed them. Then I went to so and so's room and I stabbed them. I mean, what did he do in terms of preparing his car? Did he use plastic wrap or something? Did he clean his car? What did he do with the murder weapon? Where's the murder weapon? And so forth and so on. These are many of the exciting questions I would ask him as the judge, and I would remind him if he evades or he attempts to dance in response to my exciting questions, I have the power to say, that's not good enough. Fuck you. I'm not taking your plea. So it's like, I can make you get up. I can make you under oath, tell me all the answers to all my questions. And if you don't give me the answers to my questions, I can be like, not good enough. Fuck you. So that's kind of what I hope the judge will do, but probably not. It's not like during a trial he'd be stupid enough to admit to anything. Yeah, but the trial itself would reveal what happened as much as the information would expose. So a trial, although he wouldn't speak, the evidence would answer many of these questions, if not all. So we don't necessarily need him to tell us because the evidence would tell us if it was presented in court. And so at least some of it. And so that would be good. So it's like either you can tell us or the evidence can tell us, but one way or another, we're going to find out the answers to some of these questions. How can the judge have a trial now that he's admitting guilt? He can reject the plea. He can reject the plea deal. He can reject the deal. That's how. Yeah, he can reject it. He can reject his plea. It's not that complicated. Just be like, no. It's not that complicated. You're overthinking it. Yeah. Judge could just say no. He is not allowed to plead guilty under any circumstances if the judge doesn't allow it. You're not entitled to plead guilty. The client has the decision about whether to plead guilty or not, but you're not entitled to have the court accept it. The court is not required to accept your guilty plea. Under any circumstances. If they believe in the interest of justice necessitate rejecting it for whatever combination of reasons, be like, no, you can't plead guilty. Fuck you. We're going to trial, baby. Yeah. How can you go to trial rejecting a guilty plea? I don't understand where you're getting confused by this. I don't understand what your point of confusion is. If he pled, if the guilty plea is rejected, then he is not guilty until proven guilty, in which case we would have a trial. I don't understand where you're getting confused by this. What do you mean? How could you have a trial after the guilty plea is rejected? What part of this are you not understanding? I don't understand your question. If they reject the plea, is that admissible to the jury? No. That is true. So if we did the full fat version, right? So hypothetically suppose that there's a plea and we run Mr. Kohberger through all the standard, colloquy relating to guilty pleas. And then we say, okay, take the stand, Mr. Kohberger. We're going to ask you some questions now under oath. And suppose he testifies and incriminates himself a lot. And at some point he like evades or like dicks around or something. And so the judge says, okay, I'm not accepting your guilty plea. So nothing he said on the stand would be admissible against him unless he took the stand in his own defense and contradicted what he said. So unless he tried to like get on the stand and say something else, then what was said at the plea conference would not be admissible against him. So those statements, no matter how incriminating, would not be admissible against him at trial. Unless, of course, he took the stand and he tried to lie. So yeah, that is true. He's pleading guilty. What's left to be proven? Well, for my money, I want to understand exactly all the things I said earlier. I want to understand the details of the crime. I want him to tell me the details of the crime in his own words. I want him to walk me through the crime. So I want him to tell me those things, and I want to know, and I can make him. So, yeah, that's it. He can fully say he did it and then prove self-defense? I suppose in principle. To the extent that, yeah, I mean, if he tried to claim self-defense, sure. But I guess I understand. So if he tried to claim self-defense, then okay. Yeah. If he confesses to the crime and the story doesn't match up, the judge could reject it for that reason too. That's true. If he believes that his confession is a lie, yeah. Basically, if the judge finds basically if the judge finds I'm calling it an allocution. If the judge finds the allocution insufficient for any combination of reasons, he thinks it's a lie, he evades, he whatever. If he thinks he's lying, yeah, the judge can reject it for any combination of reasons. Yeah. Yeah, all those things. And yet we've seen that happen incidentally. We've seen that happen like in other cases. We saw a case we were watching. Geez, what was it? Okay, I remember. All right. There was a woman judge, and it was a guy was being charged with, I think it was domestic battery or assaulting his girlfriend or something like that. And the allegation was, among other things, that he drove his girlfriend, or they were in a car together, and they were basically like in the lot of a store, like after hours or something. And he created some kind of disturbance, I think possibly by displaying a firearm or firing a gun or something like that. And so there was a plea deal where he admitted to, I think, because there was very serious charges, right? There were very serious charges. There was like, I think there was domestic violence, there was like aggravated assault, but I think all he was pleading to was the disturbance. So the only thing he was pleading to was essentially public disturbance. Okay. So the judge, walked him through the standard stuff as one does. And then the victim, the woman, got on the stand and gave testimony. And as I recall, she testified that this man had assaulted her, I think violently. There might have been sexual assault, but there were some fairly severe details about this gentleman not treating his significant other very well. And so the female judge, when when she heard this from the victim, became notably displeased because she hadn't accepted the verdict yet. I didn't accept the plea. So the judge became very noticeably displeased. And so the judge was asking this guy questions about what he did. And remember, he's charged with like the charges were like domestic violence, assault, domestic assault, aggravated assault, assault with a deadly weapon. It's like, it was a whole list of things, but the only thing he was pleading guilty to was the disturbing the public, right? The public disturbance. That was the only thing he was pleading to. And so this guy, genius to the cause, when he was explaining what he did to the explaining what he did to the court, he was saying, he's like, well, we just drove behind the store and we just had a conversation. And the judge is like, you just had a conversation? Yeah. What happened? And I think he said something like, well, she got out of the car and she left. So she just got out of the car and she left? Yeah. And then he said, so you didn't create a disturbance? No. You didn't create a public disturbance? No. Okay. Plea deal's rejected. We're going to trial on the whole thing, right? All the charges, the plea deal's rejected. Fuck you. We're going to trial on the whole thing. Fuck you. And yeah, that was the end of that discussion. So that was exciting. Genius to the cause over here gave the wrong fucking answer.
It will come to order. The Honorable Stephen Hitler, presiding judge.
Let me see it.
Prosecutor Santa is there. We love Prosecutor Santa.
All right, this is CR 0124316665. Defendant is present in custody with counsel, Ms. Thompson, Ms. Jennings, and pardon me, Ms. Taylor, Ms. Massoff, and Ms. Barlow. The state's present with Mr. Thompson, Mr. Horowitz, Ms. Jennings, and Mr. Nye is here as well. Am I miss anybody? I'm sorry.
Ms. Allen is here as well.
Ms.
Your
Allen
Honor.
is here as well. Very well, thank you. All right, we are here today to entertain a change of plea. Before I start, I want to address some issues of concern and otherwise. First, I appreciate everybody in attendance today being on their best behavior. Please, no outbursts or demonstrations. Any such conduct will result in immediate removal and may result in an inability to attend further court proceedings in this case. I want to point out that there have been calls by some for the public to contact me and my office in an attempt to influence my decision-making in this case.
Some people are petitioning for redress of grievances.
This has been extraordinarily disruptive for court staff.
That's very sad.
And the ability for them to get work done, not only in this case,
The public
but
is
in other
petitioning
cases where
a government
defendants
official because they're displeased. Wow, that
entitled
sounds really
to,
sad, Judge.
have their cases processed, and frankly, as important, if not more so, for victims to have their cases processed in those cases. It's also highly inappropriate.
It's also
Court is
fucking
not
legal.
supposed to,
Fuck
and
you.
this court will never take into account public sentiment in making an opinion regarding its judicial decisions in cases. Court should, and I always will make decisions based on where the facts and the law lead me, period.
That's exciting.
I have not read any of the numerous messages nor listened to any of the numerous voicemails that have been sent to me and my staff. Those have all been forwarded to security and, where appropriate, to law enforcement.
I don't give a shit. People have the right to petition their government.
Not
Fuck you.
continue to mount such campaigns or to send me information like this because, again, it is not appropriate and frankly not.
Fuck you, Judge. Fuck you. The First Amendment gives the people the right to petition the government for redress of grievances. You are the government, Judge. You are the government. And the people are not happy. They have the right to contact you and petition their government for redress. And you're like, don't contact me. I'm going to forward it to police. Fuck off. Fuck you.
Something I would take into account when deciding a matter in a case like this. I also want people to understand some very basic concepts about the ideas of separation of powers, and what the court's duties are, and what the duties and the rights of the executive, or in this case, the prosecuting attorney, is.
Really? You're going to explain this to me like I'm five?
The executive,
Seriously?
the elected prosecutor.
Seriously? You're going to explain to me what a prosecutor does and what a judge does like I'm five? So in addition to reprimanding me for petitioning my government for redresses because I'm kind of pissed, you're now going to explain to me like I'm five what a prosecutor does and what a judge does? Further, fuck you. Hey, Judge, as a member, I'm speaking to you, Your Honor. Hey, Your Honor, in this case, I'm speaking to you as a citizen of this great country who is displeased with you. I'd like to petition you to go fuck yourself as a redress to my grievances. Thank you.
Is the sole authority in deciding what charges to pursue, including whether, as well as what penalties to ask for, and what penalties to pursue, including the death penalty. This court cannot require the prosecutor to seek the death penalty.
That is true.
Nor would it be appropriate for this court to attempt to do that.
Okay.
This court, in considering a plea agreement, if it were to reject this plea agreement, cannot force the state to seek the death penalty.
This is true. That is true. You cannot force the state to seek the death penalty. That is true. But you can force them to go to trial.
My role and power in considering a plea agreement is extremely limited.
Yeah, I mean, you can't force them to seek the death penalty. That's true. I agree. So if the state wants to be all cute about this, and the judge were to reject the plea deal, because Kohberger won't play nice with others, and the state wanted to be cute and be like, we're dropping the death penalty then, I'd be like, okay, that's your call. I'm still not letting him plead guilty because you can't make me. Fuck you.
My role is to ensure that the defendant's plea is given freely, voluntarily, and intelligently. If those things are met, I can only reject a plea, such as the one in this case, where I'm not being asked to agree to the sentence in advance. If I can only reject it, for example, if the defendant does not meet or admit to all of the elements of the crime.
There is no way that's true.
That is, I can ensure what is called.
That is definitely a reason you can reject the plea, but there is no way on God's green earth the state of Idaho has somehow, by its law, made it so that is the only reason you can reject a plea. There is no fucking way that the state of Idaho has done that. There is not a chance. You absolutely can, and incidentally must reject a plea if he does not admit to the crime in the legal sense of admitting to the essential elements. But to say that's the only grounds that for which you can reject a plea, that is just a flat lie. There is no fucking way that that's true. You're lying now. You're lying to the public. Go fuck yourself. Further petition for redress. Here's a further petition. Stick it up your ass.
Called a factual basis to the plea. Finally, I want to offer my apologies to all the families, including the victims' families, the families of the defendant,
What would an actual judge in the state know? I think the judge is lying. I think the judge is lying. I'm like, I would be truly surprised. I'd be truly surprised if the law is in Idaho that the only reason he can reject the plea is the defendant does not admit to the elements of the crime and gives it knowing, intelligent, and voluntary. I'd be very, very surprised if that is the law in Idaho. So I'm calling bullshit because there's no fucking way that that's the law. That can't possibly be true. That sounds like some made up bullshit to me.
For the short notice for today's hearing, and I'm sure what must have been the hurried efforts to get here. I, like most everyone else, learned of this plea agreement Monday afternoon and had no inkling of it beforehand. Prior to that time, I was under the belief that this case was proceeding to trial. As
Beverly, maybe you should look it up if you want to. Beverly, you feel free to look it up.
Continuing to work on preparations to have
I'll leave that as an assignment to the reader. You look it up.
Ada County come to jury duty starting in mid-July. With the
Bama Law, you agree with me, right? Right, Bama Law, as a lawyer, you agree with me that there's no way it can possibly be true that the only reason a judge can reject a plea is if the defendant fails to admit to the crime and fails to basically do so knowingly, intelligently, and voluntarily, right? You agree with me that that can't possibly be the only reason, right? I mean, that sounds like some made up bullshit, right? That sounds like some made up bullshit, right?
a questionnaire process in mid-July.
Yeah, in Idaho, a judge can reject a plea if they find it doesn't serve the interests of justice. Yeah, of course they can. Of course they can. Of course they can reject a plea if they don't find it meets the interest of justice. Yeah, no shit. That's what I'm saying. I'm saying the judge is making up some shit.
It was once I learned of the defendant's decision to change his plea in this case, it was important that I take the plea as soon as possible because of the extraordinary administrative efforts.
Can we watch the hearing?
Otherwise,
you can watch whatever I decide to put on stream.
Of this,
my stream.
Getting this.
You watch
trial,
what I want to display. You want to watch the hearing? You can just go to the court's website. I mean, there's that,
and including the significant process of bringing. Again,
why do you come to a commentary channel if not for the commentary? Explain to me.
Prior to the beginning of the voir dire process.
Here's some further commentary.
And so it was important that we, if we're going to go down this road, do so expeditiously so that we can avoid those costs and expenses associated with that. Otherwise, if it was not going to result in a plea, or if for some reason the plea were to fall through today, that we could continue diligently towards trial at the time specified. And so that obviously required that we act quickly. And so some folks may have not had the amount of time that we would
You got it already? Apparently you don't got it.
For them to travel here.
Apparently you don't got it. But you can go to timeout and think about it for a while.
I apologize for that. I want to make people aware that during the hearing, if you are to leave the courtroom for any reason, you will not be readmitted during the hearing. Also, when we finish the hearing this morning, I ask that the public and media wait in their seats until the victims' families and the defendants' families and others are escorted out of the courtroom before you start to leave. Finally, I want to acknowledge the trial court administrator and her staff, the Ada County Sheriff, and the Ada County
this
4th
preamble
District Marshal Service.
This preamble is getting a little long in the tooth, Your Honor.
In preparing for and orchestrating this hearing today.
This preamble is starting to annoy me, Your Honor.
Attendant today that you see, and some of whom you.
If you're going to be a little bitch and just do the bare minimum the law requires, you could at least do it quick and save me some suffering.
Frankly, some of them while they were on some vacation.
Just get to the point, little bitch, and let me go about my day.
I appreciate very much their professionalism and dedication. All right. That said, let's move to the business of today. I understand the state and the Defense have reached a plea agreement in this case. For the record, I have a written plea agreement which indicates in sum, the defendant will plead guilty to all 5 counts in the indictment.
Great.
Burglary, felony, and first
Yeah,
degree murder, 4
burglary, that
counts.
burglary charge is really going to get you.
The state and the defendant
Super exciting we're
stipulate,
getting that burglary
that
conviction.
is
Let me
that
tell you
the,
what.
Defense is not free to argue for a lesser sentence at sentencing to the following. The defendant on the burglary charge will be sentenced to 10 years.
I thought it was
fixed,
a 10-year max.
and that
Nice.
the defendant on counts 2 through 5, the 4 counts of first degree homicide, on
Yeah.
each count would receive a fixed life sentence. All 5 of those counts to run consecutive to one another.
Yeah, I mean, no shit. Yeah, of course. Yeah.
Defendant, as part of the plea agreement, waives his right to appeal, as well as his right to appeal the sentence and his right to seek leniency or reconsideration of the sentence under Idaho Criminal Rule 35.
Yeah.
This is not a Rule 11 agreement, meaning the court is not bound by the plea agreement and could impose a different lawful sentence at sentencing. The stipulated agreement between the parties is the maximum on each count. So theoretically, the only thing the court could do would be a lesser sentence at sentencing. But the defendant is not free to ask the court to do so under the plea agreement. Are there any other material terms?
If
of the
you
plea
give him
agreement,
less than the max,
parties would like to make?
what the
Obviously, plea
fuck?
agreement, the written plea agreement will speak for itself, will be part of the court record.
Not from the state, Your Honor. Thank you.
No, Your Honor. Thank you.
All right, very well. All right. Ms. Taylor, have you had sufficient time to discuss this case and all of its ramifications with your client?
I have, Your Honor.
Have you discussed fully with him his rights, defenses, and possible consequences to him of the guilty plea?
Yes, Your Honor.
Have you been able to do all the discovery you feel necessary?
Yes, Your Honor.
And have you informed your client of the importance of providing the court truthful and accurate answers in taking this plea today?
I have.
Have you apprised your client of any and all offers and counteroffers and answered his questions about those?
Yes,
Do you consent to the entry of the plea today?
I do.
All right, Mr. Kohberger, I need to ask you some questions this afternoon, or I guess it's this morning still. I do this to ensure that so that I am assured that you understand the nature of the charges to which I understand you're going to plead guilty, as well as the possible consequences to you of your guilty pleas. I want to make sure your plea is given voluntarily, and I want to make sure that you actually committed the crimes to which you're pleading guilty, because I don't want you to plead guilty to a crime you didn't commit. If you attempt to plead guilty today, but for some reason I don't accept your plea, then it is possible that your statements today could be used against you later at trial. Do you understand that?
Yes.
All right, thank you. And now, while you're standing, actually, why don't you take the oath from the clerk?
Please raise your right hand. Do you solemnly swear or affirm that the testimony you shall give in the matter not being before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, and Mr. Kohberg, just to make it easier, you don't need to stand when you speak to me. I appreciate the sign of respect, but for convenience, you can remain seated. All
Here's
right?
my sign of respect.
Before I start asking you questions today, have you consumed substantive questions? Let me ask you, have you consumed any alcohol, drug, or other intoxicating substance that would impair your ability to understand or exercise reasonable judgment?
No.
You feel like you are thinking clearly today?
Yes.
All right, I want you to understand what the possible penalties are for each of the crimes to which I understand you're going to offer a guilty plea today. They include on count 1, the burglary, a fine of up to $50,000 and a period of incarceration of up to 10 years in the state penitentiary. You may be required to pay restitution to any victims of the crime. Count 2, 3, 4, and 5 for first-degree murder. The consequences include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your
Wow.
crime.
That $5,000 fine really going to get you.
Be enforced in the form of a civil judgment
That's great.
to operate
did a
as
little like
additional
mur-
punishment.
So
This,
in exchange
is,
for doing a
in
murder, I only
excess
have to
of
give them
any restitution or
$5,000?
fines that the court could
Wow,
order.
man.
And again,
gonna do
you
some
may
more
be required
murders.
to pay restitution to the victims of the
I'm going to do some more murders. I didn't know I could do it
would,
for $5,000, man. That's a good deal.
As to counts 1, 2, 3, 4, and 5, a DNA sample and
That's
a
a
right
good deal,
thumbprint
man.
impression.
Let's do some
and
murders.
Potentially pay for
Who wants to do
analysis
some
of those
murders?
samples.
Cheap.
You would lose any right to possess, purchase, or carry a firearm, the right to serve on jury duty, the right to hold public office, and the right to vote. Do you understand the charges and all those possible
He
consequences?
can't run for public office. It's very sad.
You've heard the plea agreement that I talked about today. Do you agree with that plea agreement?
Yes.
And do you understand the nature of the charges that you've been charged with that I understand you're going to plead guilty today to?
Yes.
Would you like to do a murder?
As I indicated,
Would you like
I'm
to
not
stab
bound by the
somebody?
plea agreement, but the plea agreement is for the maximum on each count. Do you understand that I'm not bound by the plea agreement?
Yes.
Has anyone promised you that I would be lenient or easy on you if you pled guilty?
No.
Has anyone threatened you or anyone close to you to get you to plead guilty?
No.
Has anyone, other than the state's agreements with respect to the plea agreement, has anyone promised you anything in exchange for your plea agreement?
No.
Has anyone told you to be untruthful in answering my questions today?
No.
Has anyone offered you a reward of any kind other than the plea agreement in order to get you to plead guilty today?
No.
Are you pleading guilty because you are guilty?
Yes.
And counsel, obviously there have been a number of motions filed to suppress evidence in this case. Other than those filed, are there any other motions that you felt were available with respect to Rule 12?
No, Your Honor.
And Mr. Kohberger, you understand that by entering the guilty plea in this case, you would be giving up your right to appeal any decision.
This is the worst version of this colloquy I have ever seen in my life. Seriously, is this the first time the judge has ever done this? He doesn't have it all scripted out line by line. This is the worst plea colloquy I've ever seen in my life. What the fuck? God damn.
This court made, as well as your sentence.
Yes.
Have you had enough time to decide whether or not to plead guilty?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
Given your choices, do you believe it's in your best interest to plead guilty?
Yes.
Have you discussed fully the matter of pleading guilty with your attorney, and are you satisfied with the advice you've received?
Yes.
Has your attorney advised you to your satisfaction about what your rights are, what your defenses may be, and what the possible consequences to you of your guilty plea are?
Yes.
Has your attorney done everything you've asked them to do?
Yes.
Are you satisfied with their representation of you?
Yes.
I have received a written guilty plea advisory questionnaire that is purported to be filled out by you. Did you fill that document out?
Yes.
Did you understand the questions that you answered in this document?
Yes.
And are the answers that are outlined in this document your answers?
Yes.
Are those answers truthful?
Yes.
Did you sign the document?
Yes.
And this document outlines many of the rights that you have in this case should you not plead guilty. Did you understand those rights?
Yes.
They include a right to a jury trial. Do you understand that?
Yes.
They include a right to the presumption of innocence. Do you understand that?
Yes.
You have the right to require the state to prove your guilt as to each element beyond a reasonable doubt. Do you understand that?
Yes.
They include a right to confront your accusers and cross-examine witnesses presented by the state, including by utilizing the subpoena power of the court to accomplish that. Do you understand that?
Yes.
You understand you would have a privilege against self-incrimination and a right to remain silent, meaning you would not be compelled to testify if you did not wish to, had you not pled guilty.
Yes.
Why
You
does
understand
the
you're giving up that privilege.
why does the judge sound so unauthoritative? He does understand he's a judge, right? He sounds so unauthoritative. It's like he's asking a question almost like he's asking for permission. The tone in which he's asking the question is like he's asking for permission. What the fuck? This sucks.
And those rights that I've just outlined by pleading guilty.
Yes.
All right, I want you to understand what the state would have had to.
I guess me hoping for judge balls, I was really hoping for judge balls from the wrong judge. This judge's balls clearly never dropped. Holy shit.
Proven at trial had you to the crimes that you're pleading guilty to, had you if you didn't plead guilty. Let me find the document. Hang on a second here.
Oh my God.
So as to count one burglary, the state would have to have proven that on or about November 13, 2022 in Latah County, Idaho, you unlawfully entered a residence located at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder. As to count two,
Are we sure this guy is actually a
the
judge
state
and not
would have had to have
cosplaying as a
proven that
judge?
on or about that same date in
Are we sure it's not a couple
Latah
of
County,
children,
Idaho,
wearing a
you
judge
did willfully, unlawfully,
robe,
deliberately, with
pretending to be a judge?
premeditation and malice of forethought, kill and murder
Anyone
Madison
double-checked?
Mogan, a human being, by stabbing Madison Mogan, from which she died. As to count three, the state would have had to have proven that on that same date in Latah County, at that same address, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Kaylee Gonzalez, a human being, by stabbing her, from which she died. As to count four, the state would have had to have proven that on or about that same date in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Xana Kernodle, a human being, by stabbing her, from which she died. And then as to count five, also murder in the first degree, that on or about November 13th, 2022, in Latah County, Idaho, you did willfully, unlawfully, deliberately, with premeditation and malice of forethought, kill and murder Ethan Chapin, a human being, by stabbing him, from which he died. Do you understand those things the state would have had to have proven?
Yes.
And do you understand that by pleading guilty, the state no longer has to prove those things because you're admitting those things are true?
Yes.
I want to also make, for the record, the defendant has provided with the guilty plea advisory form a document entitled Written Factual Basis that purports to have the defendant's signature dated 1 July 2025. Did you sign that document?
Yes.
And did you agree with the written factual basis that is included there?
Yes.
And then let me ask you, did you, on November 13th, 2022, enter the residence at 1122 King Road in Moscow, Idaho, with the intent to commit the felony crime of murder?
Yes.
Did you, on November 13th, 2022, in Latah County, state of Idaho, kill and murder Madison Mogan, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
Did you, on or about that same date in Moscow, Idaho, kill and murder Kaylee Gonzalez, a human being?
Yes.
The light
Did you
murder?
do that willfully, unlawfully, deliberately, and with premeditation and malice of forethought?
Yes.
And did you, on that same date in Moscow, Idaho, kill and murder Xana Kernodle, a human being?
Yes.
And did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
And then on or about November 13th, 2022, again in Latah County, Idaho, did you kill and murder Ethan Chapin, a human being?
Yes.
Did you do that willfully, unlawfully, deliberately, with premeditation and malice of forethought?
Yes.
I would ask the state at this time to provide its recitation of its factual basis had this case gone to trial.
Thank you, Your Honor. Your Honor, the organization of the recitation is different than what I think the court and the public may be familiar with from the probable cause affidavit and other documents. The state's evidence, as an overview, would show that back in March of 2022, when the defendant was residing in his parents' residence or was residing back in Pennsylvania, his home state, he purchased online a K-bar knife and sheath with an Amazon gift card that he had purchased shortly prior to the purchase of the knife, sheath, and sharpener. Jumping ahead, the end of June of that year, the defendant, Mr. Kohberger, moved from Pennsylvania to Pullman, Washington, which is right across the state line from Moscow, Idaho, for the purpose of pursuing a Ph.D. in criminal justice at Washington State University. The state's evidence would indicate that beginning July 9th of 2022, Mr. Kohberger's phone began connecting to a cell tower that serves the area of the 1122 King Road residence in Moscow, Idaho. Now, I will acknowledge for the court and all present that there are many residences in that area. It's a dense population of mostly college-related occupants. Between July 9th of 2022 and November 7th, the defendant's phone connected to that particular tower during late night, early morning hours, 10 p.m. to 4 a.m., on approximately 23 times. Now, I will acknowledge also, we do not have evidence that the defendant had direct contact with 1122 or with residents of 1122, but we can put his phone in that area on those times. In the interim, on August 22nd of 2022, Latah County Sheriff's Deputy Darren Duke conducted a traffic stop in the early morning hour or late evening hours, about 11 p.m. On the west side of Moscow, on the Moscow-Pullman Road. This was a traffic stop of Mr. Kohberger's car, which turned out to be a 2015 white Hyundai Elantra with Pennsylvania plates. During the course of the traffic stop, Deputy Duke was able to obtain Mr. Kohberger's name, Bryan Kohberger, his phone number, and his address, which at that point was an apartment address in Pullman. We then move to the early morning hours of November 13th, 2022. The state's evidence would show that early morning hours on that day, Mr. Kohberger's phone left his Pullman residence, which is an apartment in kind of the central northwest part of Pullman. That phone was then subsequently turned off at approximately 2:54 a.m. and remained off until approximately 4:48 a.m. on Sunday, the 13th of November. The state's evidence
Now I'm hearing his voice twice. That's just great. So now I'm hearing the prosecutor's voice twice. Kill me.
Would include a trial, video surveillance of a business on the Moscow-Pullman Highway, just across the state line from Moscow, that would show a vehicle matching the description of the defendant's Hyundai Elantra entering Moscow at approximately 3:02 a.m. Compiled surveillance that the investigators put together from businesses and residents then show the defendant's car, the white Elantra, as I've described, circling the 1122 King Road area, that neighborhood, starting around 3:30 or so in the morning. Comes into the immediate area of 1122 King Road, which is actually on a dead end, and then leaves several times. And approximately 4:05 that morning, the defense car had entered that area, was leaving, stopped at the intersection of King and Queen Road, did a U-turn, and the state's evidence would show that the defendant's car came back and parked behind and above the 1122 King Road residence. The state believes that its evidence would then show that the defendant entered the residence of 1122 through the kitchen sliding door on the back side of the residence, which is the side of the residence that would face the area above where the defendant's car was parked. Defendant entered the residence, went to the 3rd floor, and with a knife, killed Madison Mogan and Kaylee Gonzalez. The defendant, as he left that room, for whatever reason, ended up leaving, or the sheath for a K-bar knife was left on the bed next to Madison Mogan's body. And I can jump ahead. That sheath was tested by the Idaho State Police Forensic Lab, and single source male DNA was found on the snap of that sheath, as well as blood from both Kaylee and Madison and other trace evidence. But it's important to note single source male DNA was on the snap of that sheath. The state's evidence would show that Xana Knodel was still awake at this time. In fact, had taken a DoorDash order not long before this started. Her room was not on the 3rd floor, it was on the 2nd floor on the west side. As the defendant was either coming down the stairs or leaving, he encountered Xana, and he ended up killing her, also with a large knife. Ethan Chapin, Xana's boyfriend, was asleep in their bedroom, in her bedroom, and the defendant killed him as well with a large fixed blade knife. Each victim suffered multiple wounds. I will state for the record that there is no evidence there was any sexual component or sexual assault on any of the victims. I want to make that clear so there's no speculation. There were 2 other roommates in the house, and they were already asleep.
I guess it's better. Is it better knowing it wasn't a sex thing? Is that
one of those
better?
Awoke, looked out her door not knowing what was going on, and saw the defendant, who was dressed in black with a black balaclava on, holding some sort of container in his hand. And she saw him leave the house through the direction of the kitchen where that sliding door is that I mentioned before. At approximately 4:20 that morning.
I'll smoke it, blaze it.
So this would have been 15 minutes or so later. The defendant's car is seen on a surveillance camera for 1112 King Road, which is immediately next door to the west of 1122, leaving the area at a high rate of speed. And if the court were to see that, or anybody in this courtroom would see that, you can see the car almost loses control as it makes the corner, heads north, and then turns to go south on Walinta, which is one of the only ways to get out of that part of town. The evidence would show that following that, the defendant in his Elantra drove south of Moscow. We know that he drove on the back roads because there are surveillance cameras on the main highways, Highway 95, that would have picked up the defendant's car if he'd gone that route. And they did not show the defendant's car on that route during the time. So we know that he went through a variety of back roads in very rural, isolated part of Latah County.
You infer
About
he went through the back
4:48
roads.
that morning.
I'm not sure you can go so far as to say you know.
The defendant's phone comes back on. And the evidence will show that that phone was located south of Moscow likely at a side road intersection with Highway 95. From there, the defendant's phone activity tracks it heading back north towards Pullman, Washington, where the defendant lived. About 5:26, starting approximately 5:26, various surveillance cameras in Pullman, Washington pick up the defendant's vehicle as he enters Pullman from the south and heads north and slightly west towards his apartment, where he arrived at approximately 5:30 in the morning. Later that morning, Sunday, the 13th of November of 2022, Mr. Kohberger's phone returned to the area of King Road. We don't know exactly what he did, but it returned to that area. It's about 9 o'clock in the morning. He was there for about 10 minutes and then returned to his Pullman residence. About 9:30, the state's evidence will show, evidence taken from the defendant's phone, that he took a selfie of himself on his phone in what appears to be the bathroom of his Pullman apartment with a thumbs up. The defendant's phone then went to the Lewiston-Clarkston Valley, approximately 30 miles south of Moscow and Pullman. And the defendant is actually seen with his car at various businesses down there. This area is the confluence of the Clearwater River and the Snake River. Lewiston is Idaho's seaport. Large bodies of moving water down there. In addition to tracing the defendant's activities, as I've just outlined, on the 13th and leading up to the 13th, the state's evidence will show that following Sunday, November 13th of 2022, business records show that the defendant began searching for a K-bar knife and a K-bar knife sheath, as the state believes, to replace the one that was left at the scene of the murders. The evidence also will suggest that there were at least attempts by the defendant to delete or alter his purchase history on Amazon, where all these transactions had occurred. Later that week, the state's evidence will show that Mr. Kohberger went to what we would call DMV, motor vehicle licensing here in Idaho, in Pullman, to change his car registration from Pennsylvania to Washington. That's of note because Pennsylvania cars do not require a front license plate. The vehicles seen on the surveillance cameras of the defendant's car showed it didn't have a front license plate on it. At the time of the traffic stop by
No front license
in August,
plate. Okay.
Pennsylvania plate, no front license plate.
Okay.
Mr. Kohberger proceeded to finish his semester of studies at Washington State University and returned to Pennsylvania for the holidays. Law enforcement at this point were aware of Mr. Kohberger, had been accessing information about him, were trying to find him. They located him in Pennsylvania, and they conducted what's called a trash pull. During the nighttime hours, agents of the FBI, who assisted immensely with this case, working with the sanitation department back in this neighborhood in Pennsylvania, took trash that had been set out on the street for collection, sent the contents of that from the Pennsylvania residence of the defendant's parents to the Idaho State Forensic Laboratory, where the lab experts there were able to identify DNA on a Q-tip as coming from the father of the person whose DNA was found on the knife sheath that was next to Madison Mogen's body in the bed.
Okay.
Subsequently, an arrest warrant was issued here in Idaho, and a search warrant was issued in the state of Pennsylvania with the assistance not only of the FBI, but the Pennsylvania State Police. Mr. Kohberger was arrested at his parents' home to return to Idaho. Upon his return to Idaho, a DNA sample was taken from him, and it matched the DNA found on the knife sheath next to Maddie's body at the crime scene. I can tell the court, and the public, the weapon itself, the knife, has not yet been recovered. I can tell the court that the defendant's apartment in Pullman was searched, as well as his office.
Why didn't you ask
Spartan
him where
would
is
be a
the
kind
knife? Why didn't you
characterization.
ask
There
him
was
that,
virtually nothing
prosecutor?
there. Nothing of evidentiary
the
value
hell?
was found. And of course, we are now talking 6-8 weeks after the time of the killings. In Pennsylvania, the defendant's car was seized, and it was actually pretty much disassembled internally. And it also had been cleaned. There was a bucket of cleaner right beside it. I think we can all look to our own cars, you know, in those compartments in the doors. We try to keep them clean where you put stuff. There's always some degree of crud in there. They were spotless. The defendant's car had been meticulously cleaned inside.
Okay.
And the state would present to the jury that that was part of the defendant's plan in covering up this. The defendant has studied crime. In fact, he did a detailed paper on crime scene processing when he was working on his pre-doctorate degrees, and he had that knowledge and skill. So, Your Honor, at the end,
Apparently, he didn't have
the
enough
state
knowledge and
submits
skill, though.
the
Am I
evidence
right?
that I've given just a quick overview of, and that to present in court would consider.
Should have watched a few more true crime
state is
shows,
prepared
buddy.
to do and has been prepared to do, would show that as the defendant has just admitted and pleaded guilty on November 13th, 2022, excuse me,
Get that drink, Santa.
Mr. Kohberger entered the residence at 1122 King Road in Moscow, Idaho. He did that with the intent to kill. We will not represent that he intended to commit all of the murders that he did that night, but we know that that is what resulted, and that he then killed intentionally, willfully, deliberately, with premeditation, and with malice forethought, Manny Mogan, Kaylee Gonzalez, Ethan Chapin, and Santa Cruz. Thank you.
Thank you. All right, based on the state's proffer and importantly, based upon defendant's explicit admission to committing these crimes, the court finds there is a factual basis. Therefore, with respect to count 1, burglary, felony, how do you plead, Mr. Kohberger, guilty or not guilty?
Guilty.
As to count 2, murder in the first degree as it relates to the murder of Madison Mogan, how do you plead, guilty or not guilty?
Guilty.
As to count 3, as it relates to murder in the first degree for the murder of Kaylee Gonzalez, how do you plead, guilty or not guilty?
Guilty.
As to count 4, the first degree murder of Xana Kernodle, a human being, how do you plead, guilty or not guilty?
Guilty.
As to count 5, the first degree murder of Ethan Chapin, a human being, how do you plead, guilty or not guilty?
Guilty.
Right. The court will find that the defendant understands the nature of the charges and each offense and the possible consequences to him of his guilty plea. The court finds that there is a factual basis for the plea and that finds the defendant believes the plea to be in his best interest. I find that the plea was given freely, voluntarily, and was intelligently made. I accept the plea. I direct that it be entered. I'll continue the matter for sentencing in this case. I think it was mentioned on the call Monday afternoon, the defense wishes to waive a pretrial investigation. Is that accurate?
Yes, Your Honor.
The state also?
Yes, Your Honor, the state does not believe pre-sentence investigation is needed, given the evidence that is available. We want to, though, make sure that all of the victims have the opportunity to make statements to the court at sentencing.
Absolutely. And certainly both the state and the defense may present whatever sentencing memorandum and other documents you wish me to consider. The victims will be given an opportunity to provide the statements that they wish to at sentencing. Do we need more than one full day for sentencing?
I do not believe so, Your Honor. Obviously, we have numerous victims, and we have victims who share unique perspectives on this, and we want to make sure that they all have time to express their feelings to the court. But I believe that if we can start perhaps 8:30 or so in the morning, that we should be able to complete it all in one day.
I'll be watching it.
Defense?
I'll be
agree with
watching
that, in terms of the time frame?
Yes, Your Honor.
All right. So as it happens, we have some time reserved in this case in July
Yes, we
and
do.
August. The week of July 22nd is available. I don't know if that's too soon for the parties, or the next week, the week of August 4, is available. Any preference?
Your Honor, we're prepared as soon as the court wants to schedule it.
The state, I believe, would be prepared on the 22nd. We've told the victims' families that we're looking at approximately those dates.
All right, so because of the plan to bring in so many jurors to fill out questionnaires, I had ordered that no other trials could take place in this courthouse the week of July 22nd. And so we will use that in terms of the sentencing date because of what I'm sure will be the significant interest of the media and the public and the logistics that will be required to make that happen. Without trials going, it'll be a lot easier to do that. So let's pick that week. Why don't we pick July 23rd with the idea that if for some reason we don't finish, we could continue into the 24th. And we'll start at 9 in the morning. Does that give your team enough time, Sandra? 9 in the morning? All right. Any concerns with that date?
So 3 weeks from today?
Thank you.
No, sir.
All right. Any reason why I should not rescind the non-dissemination order at this time?
You're right. I think that given the history of this case, it would be best if that remained in place through sentencing. So we have time to make sure there's the ability to completely answer questions. That would be the state's preference and recommendation.
We'd have no objection for the order to remain in place through
All right.
sentencing.
I will, at this point, the idea to keep it until sentencing, which time it would be withdrawn in order to give the parties the space and time to prepare to meet what I'm sure will be the deluge of media requests. That's at least my preliminary decision. At this
Santa,
point.
if you want to appear on this
Acknowledge
channel
that
and
it
tell us why
seems,
you're such a
to be,
pussy, you're more than welcome to come on.
For some reason, I should.
And even more so, the judge, if you want to come on, tell us why you're such a pussy, that'll also be fine.
Obviously, I don't think the defendant, a bond was ever set for the defendant. Were it would be revoked. The prior order allowing him to come in civilian clothes is revoked, given his plea and no longer the presumption of innocence. And in fact, now the actual conviction for the crimes. He will continue to be held at the jail pending sentencing. Is there anything else today?
No, Your Honor. Thank you.
I assume that the trial date will be vacated
trial
and those
is-
4 jurors will be released.
The trial will be vacated, and I'm sure that the jury commissioner will get word to those that receive their summons that they won't be required to attend. So
Thank you, Your Honor.
that said, again, if you would all please wait for the parties and the victims' families and others to leave the courtroom before you do, I would appreciate it. And with that, we're adjourned.
Judge. Hey, Judge, why are you such a pussy? Judge, why are you such a pussy in the black robe? I didn't know that judges were such pussies. You know, actually, this is a bit of a problem I've noticed recently. I don't know if I just have like an opinion about judges or something, but like I've noticed in quite a few cases, judges sometimes are pussies. You know, judges are sometimes afraid to rule, and they're sometimes afraid to like be like, you are my bitch, and this is my courtroom, and I am your god. And I've noticed a lot of weak ass judges in a lot of cases, man. It's like a bunch of pussies out there, man. We got some weak judges out there, I guess. I don't know, man. I don't know. I thought they were made of sterner stuff. But this judge does not insist on the full colloquy, which really pisses me off. Or full allocution, or whatever we're calling it. Whatever label we give the thing. But yes, he has pled guilty to 4 counts of murder, life imprisonment consecutive, plus 10 years. Although the judge could hypothetically sentence him to less than 10 years, I guess, on the burglary, just to piss everyone else off. Not that it would really matter. And also, I think there's a fine. Yeah, I think he owes every victim $5,000, if I understood correctly. So he has to pay the victims personally $5,000 for the murder. That's exciting. So he better write it. He better get his checkbook because that's definitely the biggest problem in his day. And Mr. Kohberger will spend the rest of his life in a maximum security prison. That's super exciting. And that's kind of the end of the case. Yeah. But yeah, I was unaware that the car was found disassembled. I didn't know that. And I was unaware that there was a bucket of cleaner right next to the car. So that's pretty damning. Yeah. And so yeah, a lot of this was known. But like, yeah, we have him like in the area, and we think he did the knife murders. And I knew about, of course, the DNA matching. We knew about that. I didn't know about the disassembling of the car. That was a new detail. So that's pretty intense. Yeah, it's like, yeah, he's probably not just a clean freak who disassembles their car to clean their car. Who does that? Nobody. Not even detailers do that. That'd be like the biggest detail ever. Like, I'm gonna actually take the car apart to detail it. That's one hell of a detailer, man. I mean, yeah, that's a whole new level of detailing. So I probably not so much. The car they found, I think, because they found it in Pennsylvania. So they found, because he was in Pennsylvania when he was arrested. So they found the car contemporaneous with him being arrested, if I understood it correctly. Maybe the judge will dress him down in sentencing. Yeah. Yeah. Is it the DNA only trace? It is only trace DNA. That's true. It is only trace DNA. And trace DNA, as I understand it, is not as reliable as other forms of DNA. So it is only trace DNA or touch DNA. And so, yeah, the connection to Kohberger is a little weaker than you'd like. And also, incidentally, like, it's a little weaker, but it certainly is evidence. So, yeah, he probably would have been convicted in the end if they could have shown all those things. Plus, there could be other things they didn't even tell us about in the plea conference. There could be other evidence beyond what the state laid out, because the state is only required to lay out a sufficient factual basis to validate the plea. So there could be other evidence they're not telling us about for whatever reason. So, yeah. I look happy. I'm doing reasonably happy. Yeah. The evidence found in the knife sheath was trace DNA, right? It wasn't blood or bodily issue, correct. It wasn't tissue, correct. It was trace value that can be of negligible value. Yeah, I don't know if I go so far as to say negligible, but I would agree that it is weaker than the other forms of DNA. I would agree with that. Yeah, the tone of the judge was off. Yeah, all those things. The judge, the way he handled the colloquy, he didn't carry himself with authority. It's like the judge doesn't have authority. He's not projecting authority. He's not projecting authority. He projects himself as weak. He projects himself as like I'm not quite sure what I'm doing up here. Like, I don't know. I just want a radio contest. I just want to. That's like the projections. Like, I just want a radio contest, be judged for a day, and I don't really belong here. Yeah, he doesn't give the sense that he doesn't wear the chair of the judge's bench well, as you might say. He does not wear his chair well. Yeah, it's like he doesn't quite belong. Maybe he cleans it every week. Probably not. I've never taken the seats out of my car to clean it. I've had my car detailed before, but I've never gone so far as to take the seats out. That would be a whole new level, right? Yeah. That'd be a great day on civil law for a judge for a day. Yeah, well, when I'm licensed long enough in Texas, I think I have to be licensed for 4 years in Texas. When I'm licensed long enough, maybe I'll give running for judge a shot. See if I can find. I mean, there's a lot of jurisdiction in Texas. We're a big state, so I'll see if I can find somewhere that will elect me to be judge on civil law for judge. I will provide. I judge with snark and derision and contempt. Yeah. Yeah. Come to Narcodulces? Maybe. Yeah, I would not accept this deal under these terms. I'll tell you what, I would not accept these deal under these terms. Yeah, the only reason I can reject the plea, is if I find it's not knowing, intelligent, or voluntary, or if the elements of the crime aren't met. That's the only reason I can reject the plea. Yeah. What else should we do today? Two hours from you? Yeah, that's fine. I can run. I can run in that jurisdiction. That's fine. Give me another 2 years or something, and I'll run for judge. Would I wear glasses as judge? It depends on what the lighting in the courtroom is like. It depends what the lighting conditions are like in terms of whether I need to wear some sort of lens or something. Maybe. Where am I from originally? Well, I'm from a lot of places, but I grew up principally in South Carolina. Yeah, don't email me, servants. Yeah, exactly. Video and staff chat? Sure, let's take a look, Mandy. What do we got? Oh, P. Diddy is supposed to be second? Any second? Oh, that's exciting. So apparently the P. Diddy saga is potentially continuing. Okay, give me a second and we'll see what's going on there. Any word on Diddy? Let's see what's going on in Diddy world. If there's any video on that. Let's see what's going on in Diddy world. Apparently there's a bail hearing that's scheduled for 5 p.m. Let's check out that New York Press one because they have good information on X. What's the name of that? Bail hearing is 5, yeah. 5 p.m. is late, yeah. What is the one that does like tweets on the trial? Inner City Press, thank you. That's what I was looking for. Thank you. Thank you. Appreciate it. All right, let's see what we got. We'll just put it on put it on stream for a second so we can share what's going on in Twitter world. Cassie Ventura's lawyer is writing in opposition to bail. We write as counsel for Cassandra Ventura. Respectfully request the court deny Combs to be released pending sentencing on 2 convictions. Pursuant to the Bail Reform Act, detention is mandatory post-conviction on these charges. Ms. Ventura believes Combs is likely to pose a danger to victims who testify, including herself. Okay, well, yeah. After hearing the submission just now, bail letters by Combs, the U.S. Attorney Judge will reconvene the parties at 5 and 3 hours. So she received the hours. Judge received the notes on bail, and then they're going to have a hearing about it in 3 hours. U.S. submits letters signed by Detente Nash. Dear Judge, I'm writing to express my grave concern over the prospect of Sean Combs being released from custody. While I appreciate the fairness you've shown throughout the proceeding, I feel compelled to be unequivocal about the dangers he poses to the public and individuals who risk everything to come forward. Mr. Combs has a long, well-documented history of violent, coercive, retaliatory behavior. Over the years, he's repeatedly escaped meaningful accountability, and each time he's only reinforced his sense of impunity. If he's released now, I have no doubt he'll see it as yet another license to continue intimidating, threatening, and harming people who challenge or expose him. Many of us have firsthand knowledge of the fear that he instills around him. I can say without hesitation that he is serious and imminent threat of victims, witnesses, and broader community. His patterns of violence, particularly while engaged in trafficking of individuals for prostitution, which, incidentally, he was not convicted of, combined with unchecked substance abuse, make it clear he's not ready to re-enter society safely or responsibly. To release Mr. Combs without substantial consequence would undermine the integrity of this process and send a dangerous message that wealth and influence can shield someone indefinitely from accountability. It would also endanger those who cooperate in the investigation under subpoena who are already living in fear of retaliation. I urge you in the strongest terms to prioritize the safety of the victims and witnesses over any considerations of leniency. Mr. Combs had countless opportunities to change, and he has chosen instead to escalate. Allowing him back in the community now would be a profound mistake. Thank you for your time and commitment to protecting the public from those who repeatedly demonstrate they're unwilling to respect the law. Okay. Yeah, so both sides submitted bail letters. Both sides submitted bail letters, and let's see if we can get a copy of those bail letters. It looks like one of them is on the docket. Let's see if they're both on the docket yet. Let's see if they're both on the docket yet. Let us check the docket. The docket has all the exciting information. All right. Well, it's just the letter. Okay. We've got the letter from the assistant. Okay, we got letters from both sides, it looks like. What is this? Okay, nothing of import. All right, let's see this one from Mr. Combs. What does Mr. Combs have to say on the issue of bail pending sentencing? Let us take a look. All right. All right. Dear Judge, Mr. Combs moves for release on appropriate conditions pursuant to relevant law pending sentencing. Given the jury's clear verdict acquitting Mr. Combs of the RICO conspiracy and sex trafficking, continued detention of Combs is inappropriate. These proceedings have demonstrated, as we've told the court from the outset of this case, Mr. Combs came to New York to surrender in order to defend against the government charges because he was committed to showing his innocence. Since his arrest and detention on September 17th of 2024, Mr. Combs has obeyed the court, respected these proceedings, and demonstrated model behavior at MDC. And today, the jury unambiguously rejected the government's allegations that Mr. Combs ran a years-long criminal enterprise or engaged in sex trafficking, the core of the government's case. Mr. Combs stands convicted of 2 Mann Act counts, and his sentencing exposure is substantially lower than when the government initially sought detention. That is facts. The court should release Mr. Combs on the proposed conditions. Under relevant law, a defendant who's been found guilty of an offense is entitled to release pending sentencing if the court finds by clear and convincing evidence that he's not likely to flee or pose a danger to the safety of to any person or the community if released. Aside from the burden of proof resting on the defendant rather than the government, the operative standards are those as the same as outlined in other law. The court considers at the outset of proceedings. Thus, when evaluating whether the defendant has met its burden, the court must consider if a condition or combination of conditions will reasonably assure the appearance of the person is required and the safety of any other person and the community. As for flight risk, it's insufficient to rely only on evidence of the commission of serious crime and the fact of potentially long sentence to support a finding of risk of flight. Rather, the courts must sensibly consider several factors, including the length of prison time defendants faces and individual circumstances, whether familial and community ties make flight unlikely, his actual ability to flee and evade the law, evidenced by such things as where he has a passport, which of course could be seized, familiarity with other locations and countries, and or the financial ability to do so, and the incentive to remain provided by the anticipated harm he will benefit any sureties. Moreover, a defendant's past history of compliance with release conditions and court attendance are highly relevant. Regarding the dangerousness prong, there are two components. First, the question is whether a defendant poses a safety risk to any particular individuals, that is, any other person. Second is the safety of the community. The question is whether a defendant is likely to criminally recidivate, that is, commit future crimes against the community as a whole. As Judge Chin wrote in United States versus Madoff, this question appears to be one of propensity to commit further crimes. Mr. Combs presents no risk of flight or danger, and the release conditions proposed herein are more than sufficient to assure his appearance. Mr. Combs presents no flight of danger. I mean, he really doesn't. There's no reason for him to flee. During the initial bail proceedings, the government argued Mr. Combs was a flight risk because he is charged with serious offenses carrying significant, in some cases, mandatory terms of imprisonment. The circumstances now are the opposite. Very much so. That is true. The base offense level for the Mann Act is 14. Because there are two counts of convictions related to two separate victims, it instructs that the counts are grouped separately. Because the offense level for each group is 14, another two levels are added, resulting in a total offense level of 16. Mr. Combs is a criminal history category 1. This results in an expected guidelines range of 21 to 27 months. Mr. Combs has already been incarcerated for 10 months. So that would lead to 11 to 17 months, and then he'd only have to serve 85% of that. So, yeah. His sentencing exposure, which we fully respect and do not seek to minimize, is in fact low, and so there's corresponding risk of flight. Truth. Mr. Combs' actions prior to arrest further demonstrate he is neither a flight risk nor a danger. Mr. Combs knew he was under investigation and likely to be charged early in the year, but he was not arrested until September 2024. In the intervening months, he demonstrated he's trustworthy and committed to respecting the legal process. When it became apparent to counsel that Mr. Combs would be formally charged, Mr. Combs did something extraordinary. He left his home in Miami and traveled to New York, the very location prosecutors and agents have investigating him. Through counsel, Mr. Combs promptly told the government he'd voluntarily come to New York, offered to tell them specifically where he was, and offered to turn himself in at the appropriate time. The government rejected the offer and elected to arrest him, but Mr. Combs' own conduct was the opposite of flight. He affirmatively and proactively sought to cooperate with the legal process. I mean, that's one way of putting it. Even before his office's self-surrender, Mr. Combs demonstrated a pattern of trustworthiness and cooperation. Mr. Combs' residence were searched in March 2024, and even before that, Mr. Combs and his counsel were aware the United States Attorney was investigating him. Throughout the time, Mr. Combs acted forthrightly and remained committed to the process. First, shortly after searches on April 1st, 2024, counsel took possession of his passport. On the same day, counsel advised the prosecutors that Mr. Combs had surrendered his passport and that defense counsel would not return to him, and he would not leave the country. The passport remains in defense counsel's possession. Yeah, the court's going to want that. Second, counsel advised the government that if Mr. Combs intended to travel domestically, counsel would inform the United States Attorney. All subsequent travel is done with the government's knowledge. Third, Mr. Combs voluntarily relocated to New York. Once Mr. Combs arrived in New York, defense counsel immediately informed the government of Mr. Combs' whereabouts. Fourth, he paid off the mortgage at his residence in Miami. This payment was about $18 million for one reason alone. So they'd have the $48 million residence free and clear of any encumbrances so it could be used to secure a bond. All this shows that Mr. Combs is not a flight risk. To the contrary, he has taken extraordinary measures demonstrating he always wanted to cooperate. I'm not sure why cooperate is in italics there, but okay. With the legal process so he could establish his innocence. That's precisely what he did to the most serious charges against him. Moreover, as to the other factors the court must consider, such as familiarity and community ties, the court need only consider Mr. Combs and his family conduct over the last 10 months and prior to assure itself there's simply no risk Mr. Combs will seek to flee or recidivate. Throughout these proceedings, Mr. Combs' family has been seated by his side, demonstrating the same respect for these proceedings and support for Mr. Combs that they will pay going forward. They were here to support him and obviously committed to reuniting with his family to continue to support him, not to flee or put him at further risk. I love it, man. I love it. This is just great. This is great stuff. Great stuff. As just a few examples of what Mr. Combs has been since he was been incarcerated, he has missed the biggest moments of his daughter's life. He missed his twins' high school graduation. They didn't have any parent with them because his mother, Kim Porter, tragically passed away in 2018. He missed his twins' prom. He has a minor daughter, 2.5 years old, who's been without him for 9 months. He needs and wants to be with them and remain with his family. At today's hearing, the government suggested Mr. Combs could still be a danger in the sense that he still had means and ability to commit prostitution crimes. With all due respect, the suggestion is unsupported. The government had, and for an extended period of time, a pen register on his phone. Mr. Combs never called any potential escorts or prostitutes. Well, not from that phone, he didn't. Nor did he make any efforts to arrange meetings with escorts or prostitutes, nor was he with Jane in New York. In any event, reasonable conditions would ensure Mr. Combs would not have the ability to arrange meeting with escorts. That's really sad. That's really sad. His prosecutors are trying to cockblock. His own defense lawyers are trying to cockblock the man. That's just sad, man. That's just sad. We're going to ensure our client can't meet any more prostitutes. I thought you were supposed to have my back, attorneys. I thought you were supposed to have your back. Great. All right. Let's see. All right, where were we on this incredible letter? This glorious letter. Cases overwhelmingly support release under these circumstances. See U.S. v. Dillon. Defendant convicted of travel act for violation for running prostitute business, permitted to remain on bail for sentencing. U.S. versus Jacob. Daskal. Defendant convicted of transporting a minor, permitted to remain on bail pending sentencing. U.S. versus Lim. Defendant pled guilty to travel act violation predicated on promoting and facilitating prostitution. U.S. versus Brenner. Defendant who ran on international prostitution ring, permitted to remain on bail sentencing and only after sentence was imposed. Couldn't the feds have prosecuted him? They did. They did prosecute him. This is a federal conviction. Yeah. Yes, the feds could prosecute him. They did. Yeah. Okay, moving on. As the case stands, it's simply not in the same category of other cases where detention for a Mann Act defendant was deemed appropriate, such as United States versus Rivera Luna, where the defendant had connections to a smuggling network that smuggled in numerous victims. Other cases for further support release, see United States versus Fox, affirming pretrial release despite sex trafficking charges because the government failed to explain why the stringent release conditions imposed by the district court would be insufficient to prevent the defendant from evading surveillance in a manner that would permit him to engage in the kind of non-consensual, drug-induced violent sex acts that form the basis of the allegation of undetected. He meant BK? There's nothing. No, there's no aspect of his crime that triggers federalness. No. Yeah. Yeah, there's no federal cause of action for BK. None that I can see. But there's a lot of federal crimes. A prosecutor could probably get creative. Defense proposes the following bail package: $1 million bond, a full $1 million. Wow, that's really going to hurt. Co-signed by Sean Combs' mother, sister, and mother of his oldest child. Why would it have to be co-signed? Why wouldn't he just put the cash? Mr. Combs' travel will be restricted to the Southern District of New York, Central District of California, Southern District of New York, Southern District of Florida, Central District of California, Southern District of New York to attend court and meet with his counsel, as well as the Eastern District of New York or District of New Jersey, only to the extent his travel involves an airport in those districts. Mr. Combs' passport will be surrendered to the government. Drug testing is ordered by the government. All standard conditions. Okay, so that's what they want, and there's a pretty decent chance of them getting it, to be honest. There's a pretty solid chance of them getting all those things. Let's see what the U.S. government has to say about this. Okay. Yeah. All right, let's see what the government has to say in their view about the whole thing. The government respectfully submits this letter following the jury trial of the defendant, Sean Combs. Following a 7-week jury trial, the defendant was found guilty of 2 counts of interstate transportation for the purpose of prostitution in violation of law. The defendant has moved for bail pending sentencing under bail reform. However, because detention is mandatory under the Bail Reform Act, he's not entitled to release. Okay. Over the course of 7 weeks, the jury heard evidence of the defendant's violence, interstate transportation, numerous individuals for prostitution, drug use and distribution, and attempts to escape law enforcement. This conduct spanned 2 decades. At trial, the defendant did not walk away from these facts. Indeed, the defendant embraced the fact that he is a habitual drug user who regularly engaged in domestic abuse, because he wasn't charged with those things. Rather, the defendant argued that despite his repeated violence against his girlfriends, he didn't engage in sex trafficking. And despite his prolific drug use, he didn't engage in racketeering activity. The jury subsequently acquitted the defense of counts related to the racketeering. They sure did. The defendant was convicted of 2 counts of violating the Mann Act by transporting girlfriends and male commercial sex workers interstate for the purpose of engaging in acts of prostitution. Specifically, defendant caused these individuals to travel interstate and internationally for the purpose of engaging in freak-offs. Any of you guys want to engage in a freak-off? Where are we meeting for the freak-off? Bring your own body oil, though. You know, and party favors. Lord. Specifically, they caused the individual travel to interstate and internationally for the purpose of engaging in freak-offs or hotel nights, elaborate multi-day sex performances involving significant drug use. Defendant directed, masturbated during, and often filmed. The evidence presented over the course of 7 weeks showed that the defendant did this repeatedly, including after the defendant undisputably knew that he was under federal investigation. Additionally, yeah, a law tube freak-off might be the worst version of the freak-off ever. Yeah, the law tube freak-off. Yeah, I don't think you guys want a piece of that. That sounds like a bad plan. Additionally, the facts adduced at trial show, among other things, defendants serially abused former girlfriends, Cassandra Ventura, and that Miss Ventura sustained injuries for many of the assaults. One such assault that took place in March 2016 was captured in a surveillance video. The video, a version of which was published by CNN, showed defendant throwing Miss Ventura to the ground, kicking her, and attempting to drag her down the hallway. This is far from the only assault the defendant perpetrated on Miss Ventura. Trial testimony from mobile witnesses recounted numerous other instances of abuse, which defendant slapped, hit, kicked, and dragged Miss Ventura by the air. As long as there's consent and snacks, we could have some snacks. This incident, month after defendant's residence were searched by federal agents, where defendant unquestionably understood that he's under federal investigation for sex trafficking with force, fraud, and coercion. Facts of trial also showed defendant regularly bought and consumed drugs, including drugs he provided to Miss Ventura and Jane during the freak-offs. I got 99 problems with a bitch ain't one. Hit me. That's Jay-Z, but still, I mean, it's just what came to mind. In addition to June 2024 violence involving Jane, defendant also engaged in other criminal conduct while I was aware that he's under federal investigation. During the March 2024 searches of defendant's residence, law enforcement recovered narcotics and 3 separate firearms with defaced serial numbers. I'm really surprised they didn't charge him with the possession of the firearms. That's a felony. They didn't charge him with the defaced serial number thing. Why not, man? Why didn't they charge him with that? That's lame. Further evidence at trial established defendant. Maybe they want to charge him in a different jurisdiction for that. Maybe they couldn't charge him in New York, but they want to bring charges in a different jurisdiction. I would if I could. Tell you what, I'll get those years. Further evidence at trial established defendant engaged in transportation for the purpose of prostitution with Jane as recently as 2024, a mere month before arrest, when Jane had sex with an escort in front of defendant at defendant's 2-star Islander residence. 2-star? I'm confused. Indeed, the defendant was planning to fly Jane to New York for the same purpose in September 2024, mere days before the arrest. In September 2024, at the time of the arrest in Manhattan, law enforcement recovered $9,000 in cash and drugs, including MDMA and ketamine, from the defendant's hotel room. The guideline calculations in this case is complicated, and the government expects that will have to be litigated. For the purpose of the detention hearing, the government sets forth below the preliminary calculation subject to review, which it believes is the minimum. So they're going to go through the offenses and try to do it. All right. So because it involved more than one victim, Part D applies to this. Because there are more than 6 victims, each victim has been convicted. More than 5 groups, each group has a victim of 15. So they believe the offense level is 22. We'll have a fight over the offense level. The evidence at trial shows defendant was a manager or supervisor of one or more parties. Further, the criminal activity was otherwise extensive. While considering whether criminal activity is extensive, blah, 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 blah. So they think he obstruction of justice, blah, 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 blah. So they think the total offense level is 24. Okay, that's what they think. Based on this office's current understanding, defendant has 0 criminal history. Accordingly, based only on preliminary calculations, they think 51 to 63 months. That could happen. Yeah, I mean, all those like sentencing enhancements, there's going to be a fight over that because when I ran the numbers, I assumed no enhancements. And so the government is assuming a lot of enhancements. So to get to 51 to 63 months. I feel like they wish for 51 to 63 months. I don't think they're going to get it. But, we'll see. The government knows, although, it could go a lot of different directions. The government notes, however, the guidelines applicable at sentencing may be higher than the preliminary calculation. The government has not adequate time to carefully consider all potential applications. For example, as the court is aware, evidence president's trial for defense on count 3 and 5 overlaps substantially with evidence relating to sex trafficking. According, much of this conduct is not included in the guidelines definition of acquitted conduct and may be relevant to the guidelines calculation. For instance, the government seeks to use the application for instance, the government expects to seek application of 4-point enhancement pursuant to law. The government may require additional time to consider other potential enhancements. The Bail Reform Act governs whether a recently convicted defendant is eligible for release pending sentencing. Under Bail Reform Act, detention is mandatory for defendants convicted of certain specified crimes. Specifically, under some law, crime of violence includes any felony under Chapter 117, and a violation of the Mann Act falls under that subsection. Specifically, where defendants been convicted of a crime of violence, so they're saying this is a crime of violence? I'm not sure I buy that. Yeah, I'm not sure I buy that argument legally. Yeah, not especially in view of relevant U.S. Supreme Court cases, because the crime does not have an element of violence. So even if it fits into a category, I don't think it's a crime of violence. I don't think I buy that, but I appreciate them trying. Specifically, where a defendant's been convicted of a crime of violence and is awaiting sentencing, defendant is here, the provides the court shall order defendant be detained unless the judicial finds a substantial likelihood the motion for acquittal or new trial be granted, or the attorney for the government has recommended no sentence of prison be in prison, and Judicial finds by clear and convincing evidence not likely. Defendant must fill both prongs of this set out. Defendant must demonstrate by clear and convincing evidence they're not likely of free and non-danger. Clear and convincing evidence that would produce in the mind trier of fact a firm belief or conviction as the truth of the allegations. Absent government recommendation that no sentence of imprisonment be imposed, these conditions are nearly impossible to meet. Yeah, pretty much. The Bail Reform Act permits a limited safety valve for mandatory detention. Under law, if a defendant subject to detention may be ordered released under appropriate conditions, two requirements are met. First, district court must find by clear and convincing evidence the person is not likely to flee or pose a danger. Second, must be clearly shown there are exceptional reasons why the person's detention would be inappropriate. Exceptional circumstances exist where there's a unique combination of circumstances giving rise that are out of the ordinary. Defendant must be detained pursuant to the Bail Reform Act as detailed above. The offenses constitute crimes of violence. I'm not sure I buy that. And mandatory detention following defendant's conviction. Here, defendant's been convicted of two such crimes. Because the near impossibility of meeting the stringent criteria set out in law, the only conceivable basis for release is the existence of exceptional circumstances. However, the Second Circuit has recognized that exception is very narrow. Indeed, the circuit has reversed the district court's decision to release a defendant on bail pending on this basis. Okay. The defendant utterly fails to show exceptional circumstances here. I think that's true. As detention is mandatory following conviction, I'm not sure that's true. The government has been unable to locate a case in which defendant was released from custody following such a conviction. Indeed, the government has only identified several cases where defendant was detained pre-trial and remained detained through sentencing. And then they cite a whole bunch of cases. Here, there's yet a heightened burden they must carry out because he's been convicted of two felony offenses because of mandatory. They certainly want to be mandatory. Even if detention were not mandatory, which it is, defendant cannot meet the burden by showing clear and convincing evidence he's not likely to flee or pose a danger. First, given the significant possible penalties, the government believes he continues to be a flight risk. As described in the law, as minimum, defendant faces guideline range of 51 to 63 months. That's going to be disputed to hell. And the guidelines range found sentencing may be higher. The possibility of substantial sentence such as this is a significant factor in assessing the risk of flight. Okay. Okay. Further, while defendant has offered to have multiple sureties from his family, evidence at trial establishes defendant repeatedly sought to conceal his crime conduct from those close to him. Second, defendant cannot meet his burden to demonstrate by clear and convincing evidence that he's not a danger to the community. The overwhelming evidence established at trial, which defendant did not dispute, shows the defendant has engaged in years-long pattern of abuse, including as recently as June 2024, approximately 3 months before his arrest. Despite the knowledge he was under federal investigation, and they put that in italics, I'm not sure why, defendant nevertheless brutally assaulted Jane, leaving injuries that were visible for days after the assault. Additionally, when defendant traveled to New York, where according to defense counsel, defendant was waiting to be arrested, he was in possession of drugs and materials necessary for the freak-off. So he came to New York to surrender himself, but he brought drugs with him and baby oil and stuff. Man, this guy's insatiable, man. This guy's a lot, man. Great. Defense conduct after he stood is under federal investigation underscores that he continues to be a danger to others. He is unable or unwilling to follow the law. Okay. For these reasons, defense conduct is continued detention is required. Yeah, I can see that kind of going either way. I think it's definitely possible he'll be released, and I think it's definitely possible he won't. So I am alone. And I think the government is hoping that they'll be able to get a sentence of 51 to 63 months. Or that they'll get a range in that option. I think they're hoping that he's going to get like 5 years. I mean, that's possible that he get 5 years, but I mean, it seems like a bit of a reach. But you can't blame the government for reaching. You reach for those stars, baby. Reach for those stars. So 0 to 5 years basically is time served to 5 years, I suppose, more appropriate. Yeah, time served to, I guess with time served, it would be time served to, 4 years and 2 months. Seems like the range of plausible outcomes. Something in that number. So, yeah. Okay. Kohberger unaliving fines? You made a clip of me talking about the unaliving fines? That's cute. Yeah, Miss Mandy made a little clip for us of me talking about the unaliving fines. Okay, hold on. Okay. Did he do it? He pled guilty to it. He said he did it. So
Include a fine of up to $50,000, a period of incarceration of life imprisonment, which is a requirement of a sentence, that it be a life sentence with a mandatory minimum sentence of at least 10 years on each of those counts. In addition, you would be potentially responsible for a fine of up to $5,000 to each of the victims of your crime.
That $5,000 fine really going to get you.
Be enforced in the form of a civil judgment.
That's great.
To operate
did a
as
little like
additional
mur-
punishment.
So
This,
in exchange
is,
for doing a
in
murder, I only
excess
have to
of
give them
any restitution or
$5,000?
fines that the court could
Wow,
order.
man.
And again,
gonna do
you
some
may
more
be required
murders.
to pay restitution to the victims of the
I'm going to do some more murders. I didn't.
consequences.
Yep. Yeah, pretty much. Yeah. So yeah, definitely all those things. Yeah. All right, cool. All right. Anything else before we wrap up the stream and call it a day? Anything else before we wrap it up and call it a day? Or are we done? I'm your favorite law tuber. That's very nice. Thank you. I have to be someone's favorite. I switched antidepressives, so we'll see if that does me any better. I don't remember the name of the new one because it was a name I've not heard before, but we're giving that a try. So I had been taking Vyvanse, as you guys know, basically as an antidepressive, but it was causing me to have some high blood pressure. So I switched back to modafinil, which I've used in the past, and added in a antidepressive, which I don't remember what the name of it is. So I just started taking that yesterday. So we'll see if that does me any good. We'll give it a shot. All right. Well, I don't see anything else in chat, so I guess I'm going to go ahead and sign off. So thank you for spending some time with me. I appreciate you being here. I'm going to go ahead and sign off. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers, my friends, for now, and goodbye.